So I'm going to respond to this question. So what do I do with my opinion? And this is someone asking, or they posted this question on my video where I'm explaining that state court decisions, orders, judgments, or entries written in the judge's name and title only and not invoking the jurisdiction of the court. So if you're in state court, you're likely in a county court, it should say the judge's signature and then underneath judge of such and such county district court, and then have the state court seal. If it does not invoke the court that they are an officer of, then they are operating without jurisdiction of any kind, because jurisdiction is with the court, not a person. Here's the case law again. Jurisdiction is lodged in a court and not a person. The judge exercising the jurisdiction acts for the court. So if they sign an entry or an order, just their name and their title only, that is an administrative act. That's in their administrative capacity, or they are in vacation. In short, that is not an order, judgment, or entry of a court. So if you file something very simple, a constitutional question, to a federal court, you take that judgment and you file to the federal court for declaratory relief or injunctive relief, you may get an answer back that looks like this. If you start filing to the federal court about all the things that that particular judgment says and what it's violating, then they may respond back with the Anti-Injunction Act. Provides that, quote, a court of the United States may not grant an injunction to stay proceedings in a state court except as expressly authorized by an act of Congress. This is why I'm saying just ask the federal court the constitutional question on whether or not that judgment is a violation of Article 3 of the U.S. Constitution. Because Article 3 is, and actually this is the act of Congress that you can cite. It's the Judiciary Act of 1789. But this is the act in which Congress conferred the power of governmental law to the Supreme Court. So basically, it is a constitutional question for you to ask the court to intervene, or if you ask for an injunction, and that the injunction is warranted due to the fact that the Judiciary Act of 1789 was an act of Congress conferring governmental power of law to the court. And this judgment by the judge is not of a court, which also bars the abstention, the Younger doctrine, and the argument that they should allow state courts to proceed all the way through and litigate their own matters. This does not apply because there is no relief for a litigant. There's no remedy at law for a judgment in a higher state court that is not of a court. They do not have the power, the appellate courts and the state Supreme Courts do not have the power to reverse or to review even a decision, order, or judgment that is not of a court. So like I said in my post earlier this evening, my personal suggestion is to make the argument extremely simple. You need declaratory relief. You're asking for the federal court for an injunction. for a declaration that said judgment by the judge without any jurisdiction of the court is null and void, is an actual lawful nullity. And the federal court must intervene, and I believe you're triggering official judicial review to determine a constitutional question. And the reason that I believe this, I know someone who has filed a similar argument, and what immediately went to a magistrate in federal court caused that magistrate to spontaneously recuse and put the matter before the district judge, because all constitutional questions must be decided and determined or have judicial review, not from a magistrate, I believe. But the person filing did not object to her complaint being assigned to a magistrate, and the magistrate just sua sponte recused. So that's why I believe that happened. But anyway, to recap, in my opinion, the simplest, most direct complaint to file is a constitutional question on whether or not your judgment, order, or entry signed by your judge, your state judge, in their name and title only, without invoking the jurisdiction of the court that you are in litigation and whose governmental power of law that judge is supposedly the steward of, is that judgment a lawful nullity due to the fact that it's a violation of Article 3 of the United States Constitution? I would ask the court for declaratory relief and injunction, and the argument in support of the injunction would be the Judiciary Act of 1789, which is an act of Congress where Congress conferred the power of governmental law to the court. Additionally, I personally would include the statement that there is no remedy at law in higher courts or with a higher state court due to the fact that they are only, per their own state constitution, conferred the power to review and reverse judgments from a court. So that means the only place to go is for justice, and a remedy is that federal judge. Once you have that said judgment declared a nullity, then I believe you can file against that judge that wrote said judgment in their personal capacity, and that's where you would pursue damages and get, where you would challenge the immunity, the absolute immunity, because although writing an order is a judicial act, when they do it without any jurisdiction, meaning without the court, then they lose their qualified immunity. They know the law and they know what they're doing. But I believe that's when you want to request a trial by jury, because you already have a federal court confirming and declaring that judgment has no lawful governmental force of law. As one person who has a family member who is an old retired attorney, I think he said, "Keep it simple, stupid." But I happen to agree with him. If the argument is extremely simple, it's hard for them to dismiss.